SJC-12812, M. Christine Shaffer, v. Commissioner of Revenue.
Good morning, Your Honor. Attorney Leo J. Cushing.
Cushing,
for the appellant.
one second. Let us get the clock to go, and then you can. Okay, we're all yours. Go ahead.
Thank you very much, Chief Justice and Justices of the Supreme Judicial Court. Thank you for having us here. Leo J. Cushing, attorney for the appellant Christine Shaffer. With me is Attorney Janet Wallenitz, who has helped on the brief. This is an estate tax case that calls into question whether General Laws Chapter 65C, Section 2A violates the Article 10 of the Massachusetts Declaration of Rights, the 14th Amendment of the United States Constitution, and Article 4 of the Massachusetts Constitution. Let me give you some background. This case involves a married couple. In this case, it's a husband and wife, where the husband, Mr. Chuckrow, died a resident of New York in 1993, survived by his wife, Mrs. Chuckrow, who also at that time was a resident of New York.
I just want to short-circuit this a little bit and just ask you, you want us to say that Massachusetts cannot collect the estate tax or death tax on a Q-tip, right?
Yes, a Q-tip where only a federal Q-tip election was made on the first death. No Massachusetts Q-tip election was made on the first death.
Okay, but, so this would be a loophole then for anyone to avoid state tax, right, on their Q-tip. All you would have to do is the first person to die dies, the money flows where it's supposed to go, and then the surviving spouse moves out of state.
Yeah, that is the case as it is right now in Massachusetts. For example, if there's a Q-tip election made by a Massachusetts decedent on the first death, and then the surviving spouse moves out of state, Massachusetts does not have jurisdiction to impose an estate tax on that.
That's fair. I think that's fair, because nobody's there. But,
yeah. But in this case, in order to have an estate tax, we have to look at the constitutional requirements. The first requirement is that there be domicile. We have that here because Mrs. Chuckrow moved to Williamstown and died. What we don't have is a transfer by Mrs. Chuckrow. What we have is the Massachusetts statute that basically imposes an estate tax based upon a federal state death tax credit going back to the year 2000.
But if she had stayed in New York, right? New York could have certainly taxed this,
yeah,
right?
No question, Your Honor. Yes.
So why? And the tax is delayed because the money is, or whatever, these investments are transferred to her, and then she takes this money and moves to Massachusetts and then dies. Isn't it assumed you're going to tax this on the death of the second person, right?
Let me explain it that way, and we really need to get into the essence of a Q-tip trust. The money wasn't transferred to her. The money was put into a trust in which the income only was payable to her. Principal could be payable to her in the trustee's discretion.
I get all that. But again, if she lived in New York, she would have been taxed for this at her death in New York, right? It's just that when she moves to Massachusetts, again, with all of this stuff moving with her,
right?
Why Massachusetts can't tax her? Because otherwise, as Justice Budd just said, there's no taxation on this.
And put into that question that it's intangible property as well, into Justice Kaffer's question.
In order to impose an estate tax at death, there must be a transfer. Simply because a federal Q-tip election was made, and simply because there was a New York Q-tip election made, does not equate to a transfer.
What definition are we using for transfer?
For transfer?
Yes.
Well, I've been at this a while, and one of the most interesting definitions comes from the regulations. It gives an example of a burial plot, which sounds kind of crazy, but a burial plot has value the moment of death. But only that portion in which the decedent is not buried is subject to the estate tax, because only that portion is transferable. We can also look at the essence of the trust itself.
You just lost me on that one.
Excuse me?
Maybe
Yeah, that wasn't,
that one.
we
so-
didn't get it.
We didn't, you better explain this. That means if you're
get it when I
buried
read
in
it,
6
didn't
feet of land, they can only tax the 7th foot?
That comes right from the Internal Revenue Code regulation. But let me give another example. Assume for the moment that the trust in question, where income is payable to the surviving spouse, principal is payable in a trustee's, not the surviving spouse, and the spouse has no power to direct where those assets go on the second death. If a Q-tip election had not been made for federal estate tax purposes, we wouldn't be here today. That is not sufficient to constitute a transfer. The federal government knew this when they enacted the Q-tip provisions. Go back to 1980 when the marital deduction was limited to 50% of the adjusted gross estate, and it was changed to 100%. But it was then the first time that Congress said, well, let's let assets be put into a trust for the benefit of the surviving spouse, but that right will terminate on death. The first spouse basically has the right to control the disposition of the assets. That's where the transfer takes place. Congress had to create basically a fiction. So they knew that if you had a trust that provided income only to the spouse had no control over the final disposition, it would not satisfy the requirement of a transfer. So they created 2056B7, which said, if a trust provides that income is payable to the spouse, no person has any power to appoint any property to anyone but the spouse, and then on the death of the surviving spouse, the assets come back to those persons designated by the first spouse to die. It's a qualified, terminable interest trust.
Yeah, but everybody, we understand that the tax is deferred and that the property is never the second spouse to die's property.
It's not her property, yes.
We got that. The problem is, you got to go back to Justice Bud's question, though. For the purposes of whether or not a tax is constitutional, what constitutes a transfer? Because the day before she dies, the second spouse dies, the day before she dies, she has a life interest in this intangible property. And then on the next day, her beneficiaries have it.
Correct.
So the question is not, everyone understands how the Q-tip trust works. The question is what Justice Bud asked. What's a transfer for the purposes of a constitutional analysis of this tax?
There are several other courts that have addressed this, in particular the Connecticut case in Brooks and also the Bracken case out of Washington. In both of those cases, the Bracken case was decided where there was no transfer on virtually identical facts. What happened in Bracken, that was followed by the Hamilton case where the legislature created a standalone estate tax, which specifically defined the state gross estate to include the federal gross estate. The court concluded that the legislature intended to have transfer interpreted in its broadest possible fashion. We don't have that here in Massachusetts. The other case would be the Supreme Court case of Fernandez. This was a case arising out of Louisiana involving community property. And the question is whether the entire property owned by a husband and wife should be includable on the first death. And the court said, yes, it should. Not only the half that the spouse had who died, but also the half that passed to the surviving spouse. And here's the language of the court. Any creation, exercise, acquisition, or relinquishment of any power or privilege which is incident to the ownership of property. The Fernandez case is about the most liberal interpretation of transfer that we could find.
Mr. Cush,
Here,
can I ask,
excuse me?
can I ask you just a very rudimentary question, which you can scoff at later, right?
Or scoff at now.
Scoff at, no, it's up to you. So in Massachusetts, suppose this Q-tip had existed in Massachusetts, right? And estate taxes are deferred in Massachusetts, right?
Yeah, so the first
All right,
spouse.
for the first spouse, and then the second spouse dies. Well, we don't have anything involved with Connecticut. We just have Massachusetts and Massachusetts. right? Is it taxable, in your opinion, in Massachusetts on the second spouse's death?
If we follow the interpretation of the Commonwealth's 2A, the answer is no, and this is a big problem with what they're suggesting. The federal exemption amount now is $11,500,000. If we just assume for the moment that we had a $10 million estate, there would be no reason to file a federal return. There's no reason to make a Q-tip election at all for federal. However, you can make a Q-tip election for Massachusetts, which would, if we assume a $10 million estate, that would defer $9 million of assets for state taxation until the death of the survivor. The problem with their interpretation is that would not be subject to tax in Massachusetts because they want to use the definition of, quote, the federal gross estate. There's nothing in the federal gross estate. You would only have a Massachusetts Q-tip, which would escape estate taxation. That's how you read their position on Chapter 2A.
And we'll give them a chance to talk about their interpretation, but your interpretation is, unlike the loophole we asked you about, there is no loophole because if it was solely in Massachusetts, there wouldn't be it wouldn't be taxable.
Your Honor, I appreciate the word loophole, and I've been at this for 35 years, and I really don't consider good planning.
No,
like moving to Florida.
Believe me, if I had
this is what we do.
If I had assets, I'd look for loopholes. But
You would.
Yeah.
It's not a loop. In this particular case, I would suggest that it's a constitutional infirmity.
well, okay.
But as to the issue of the transfer, things happened upon her death. So the life estate which she had is no more, and so now the beneficiaries have total control, correct?
The beneficiaries do have total control of the assets as trustees, yes, Your
And,
Honor.
and if I'm correct, if they were wise enough at the time to put all the stock, they did well apparently over the years, but if they were wise enough to have put all of that estate into Apple stock, and they had bought that Apple stock in 1993, whenever he died, at $10 a share, and that stock is now worth $1,000 a share, the cost basis for that would shift upon her death to $1,000. So if they were to sell that stock, the capital gains for that stock would go from $990 a share to zero. Correct?
Yes, in fact, in this case, the real estate that was the subject matter of the Q-tip trust was worth about $800, and it increased to about $13 million.
Okay, so
by the time the surviving spouse
isn't
died.
that effectively, there is a transfer, the law creates something which gives them a new cost basis, and would that not then qualify as a transfer as required under the law?
I would address that in the context of the Federal Internal Revenue Code provisions that spin a web. Basically, 2056B7 allows for the Q-tip trust to be deferred until the death of the surviving spouse. There's a corresponding code section, 2044, that says, look, if you took a deduction on the first death, you have to include it on the second death. But in particular, code section 2044C recognizes this problem, and it statutorily says, this is the that property included under 24A shall be deemed to have been transferred by the surviving spouse. We don't have that in Mass. It's a fiction that was created in order to allow for the deferral of federal estate taxes on the first death to the second death. You're dealing with Code Section 1014, which is the step-up in basis provisions. Again, there's a provision there that says if an asset was includable in the estate under Code Section 2044, it does get a step up in basis for federal estate tax purposes. But that doesn't have anything to do with the Commonwealth of Massachusetts. The question is whether is there a transfer sufficient to justify the imposition of the Massachusetts estate tax.
My question, I guess, is, to be more blunt, is you seem to be prepared happily to embrace the fiction of a transfer with regard to the stepped-up cost basis, but are telling us we should not embrace the fiction of a transfer with regard to the taxability of the estate.
I'll address it that I embrace the provisions of the Internal Revenue Code that allow for a deferral, includability on the second death, and a corresponding step-up. What I object to is using 2A as a hammer. We still have to look at whether there was a transfer on the second death. You know, in this case, remember, the Connecticut case, the Brooks case, is very different, but that's the case that counsel relies upon. And in the brief, they suggest that in Brooks, the surviving spouse had some control over the final disposition of the assets in the Q-tip, and that's not factually true. In Brooks, the spouse was entitled to all the income. The spouse was a trustee. That's not the case here. But more importantly, in Brooks, the spouse was given a limited testamentary power of appointment to basically use the Connecticut court probate system to reallocate the assets. That's simply not the facts in this case.
Can I ask you a question about the Section 2A? What is the infirmity in that statute that keeps Massachusetts from being able to collect?
The main infirmity is that it doesn't take into account what is a transfer for Massachusetts estate tax purposes, and two, more importantly perhaps, we think it's unconstitutional on its face.
No, I understand the unconstitutional part. I don't buy it, frankly, but the first part, the transfer part, help me understand. If it's not defined in the statute, isn't it up to us to figure out what it means?
If it's not defined in the statute, and these other states that have upheld this type of a transfer have been guided by the legislature, where they have included a broad definition of the term transfer, we don't have that here in Massachusetts. We seem to adhere to the old maxim that tax statutes need to be construed strictly against the taxing authority. And so I don't see how you get that there's a transfer under state law under 2A, Your Honor.
Okay. Chief, can I ask one last question? Sure. Yeah. So, and this is along the lines of Justice Gaziano, rudimentary, but what's the principle? I understand the Commonwealth's principle. Look, this was deferred taxes, and it should be paid when the second spouse dies. What is the principle that justifies no taxation whatsoever because she moved? Just tell me, as opposed to sort of a technical, and again, I won't use the word loophole, but just tell me why it's principle that there should be no taxation here.
In order for a state to impose the estate tax, there must be domicile and a transfer. So if someone dies in Massachusetts, the first spouse dies in Massachusetts.
I understand your, I disagree with you on, domicile is easily satisfied. The transfer one will go fight back in our offices what the transfer is. But the principle that there should be no taxation here is what?
The principal reason there is no taxation is because there was no transfer on Mrs. Chuck Rowe's death under state law. There is nothing, she had no interest, she had the right to receive income. That's no different than if you were to give your spouse a life estate, no Q-tip election, and then she dies. That's not includable in her estate. The only reason we're here is because a Q-tip election was made. And it doesn't seem reasonable that the making of a federal Q-tip somehow creates a property.
If she stayed in New York, it would be principled to tax it. But because she's moved to Massachusetts, the same thing happens when she dies in New York as when she dies in Massachusetts.
No, if she died in New York, there was a New York Q-tip made, so New York would have collected a state death tax.
So the principle you're relying on is that they did a New York Q-tip back on the first one. They didn't do a Massachusetts Q-tip.
Correct.
Therefore, it's principled not to allow anybody to tax it.
By moving out of the state, she would have avoided a tax. And you know, the federal government deals with this with non-citizen spouses and Q-tip trusts. The other option is for the government not to allow a Q-tip on the first death. Why allow for a deferral if you know that the surviving spouse can move? There are statutory solutions to this. But we're asking this court to determine that, as applied in this case, where there is no power of appointment, no ability of the surviving spouse to utilize the mass probate court to in any way direct things, that the appellate tax board erred in finding that there was a transfer.
Okay, thank you.
Thank you.
Ms. Foscade-Condon.
Good morning, Céline de la Foscade-Condon for the Massachusetts Department of Revenue. With me is John Connors, also from the Massachusetts Department of Revenue, and may it please the court. The issue is whether the Q-tip assets, which were not taxed at the time of Mr. Chukro's death, should be included for computing the Massachusetts estate tax. And the board correctly decided that it should, in accordance with the statute and in accordance with case law. So while the estate recognizes that the purpose of a Q-tip election is a deferral of the estate tax when the second spouse dies.
Can I stop you for just a second? Because I want to get to this transfer thing. Why is your brother wrong in saying that there is no transfer here? And, you know, given that the statute doesn't say what transfer means, where are we getting the definition?
So under property law, there was indeed only one transfer at the time of Mr. Chokro's death. But because there was a Q-tip election, you do have those two fictional transfers. So in terms of tax law, these issues of fiction is really not an oddity. Under tax law, you often have fictions. For instance, you would have an asset sale, a stock sale that is treated as an asset sale under 330H10. You would have disregarded entities. Those are real corporate entities but are disregarded for corporate purposes. So here you do have two fictional transfers, and you find those two fictional transfers under the code. Under 2056B, you would have the Q-tip asset shall be treated as passing from the first to die spouse to the surviving spouse. And then you do have a second fictional transfer that occurs when the surviving spouse dies, and the Q-tip asset shall be treated as property passing from the surviving spouse under Section 2044. And that is the second fictional transfer that does trigger the estate tax, and the entire value of the Q-tip assets are included in the federal gross income. Also, the definition of transfer under the appropriate case law is very broad. Also, because we are incorporated a federal concept here, because we are looking at the federal gross estate to compute the Massachusetts estate tax, we have to look at the interpretation by the feds. Has this
I saw that in your brief. Where is it Fernandez that you're referring to, that transfer under the Internal Revenue Code is to be treated as a very broad concept?
That's correct. Under Fernandez, under Morgan's, also if you look at the Bracken case, which was superseded by a change in statute. So in Bracken, the court had adopted a very narrow definition of transfer, saying this is what the legislature wanted. And the legislature, after changed the statute of saying, no, you got it wrong, actually you really have to adopt a definition of transfer as the feds wanted it, and it's a very broad definition. Under the federal interpretation of transfer, it's really a transmutation of rights, and that's really what happened here.
For Bracken, though, couldn't you see it as the legislature saying, "Oh, we should have made the definition broader, so we're going to do that"? So the court didn't necessarily get it wrong; they just interpreted what was there.
But this court, in the BW Co case, which was a personal income tax case, stated that when you adopt federal statutory, as we have done here under 2A, you also adopt the federal interpretation. And here, because it is a very broad interpretation, you would also look at transfer here in a broad way as a transmutation of rights. And the death of Mrs. Chokro causes transmutation of rights. While she did not own the assets, upon her death, the beneficiary now could receive the assets, which it could not prior to that. Talking also about, also the assets here are intangible assets. My brother has enumerated a litany of cases that stand for the proposition that a state is constitutionally prohibited from taxing transfer of properties that are located outside of Massachusetts. All of those cases that he cited are all cases related to tangible personal property or real property. Massachusetts is not asserting that we have a right to tax such transfer, but because here the assets at issue are intangible assets, Massachusetts, as the state of domicile, is constitutionally entitled to tax those assets. There is no dispute that Mrs. Chokro was domiciled in Massachusetts at the time of her death. Also, I would like to address,
So if it were the house, so if the asset were the house in New York, and they had a Q-tip, and she moved to Massachusetts and lived in some rental in Williamstown, we wouldn't be able to tax that.
that's correct. So we would remove the value of those assets from the federal gross estate in order to compute the Massachusetts estate tax. Addressing also Chief Justice Gantz regarding this issue of,
Can I finish that thought? So I'm concerned about sort of understanding the logic of certain, would that be totally untaxable then? Would it be again, if it were the house as opposed to stock or something like that, would that mean that if she died in New York, they could tax the house, but now that she's moved to Massachusetts, they don't get to tax it, or they just tax it under a different provision of the
no, so
state?
New York would be entitled to tax the transfer of a property that is located in their state.
So
be
there
it a
would be
house-
taxation under that Q-tip of the property. It just would be in New York, not Massachusetts. We wouldn't have this gap, as Justice Budd's first question, where nothing gets taxed, right?
That's correct. I mean, there's circumstances where something can be like, there would be no estate tax. For instance, if Mrs. Chokro had moved to Florida, where there's no estate tax at all, then indeed, because of the deferral, there would be no tax.
So in that case, if she moved to Florida, there's no problem with there being no taxation, but it's just that she moved to a place where you allow these taxes. Okay. Yep.
That is correct. And the New York Q-tip election has nothing to do with Massachusetts seeking to tax the estate here. So Massachusetts estate tax is based on the federal gross estate. So even if there was no Q-tip election made in New York, Massachusetts would still be asserting there would be an estate tax because we're only looking at the federal gross estate. So Justice Gantz got it right in terms of the appellant's position regarding transfer, stating that there is no transfer for purposes of an estate tax in Massachusetts. That is the position they're taking. However, they are taking the position there is a transfer for the stepped-up basis. Also, and this is only for federal purposes, since Massachusetts does not have a gift tax or a generation skipping tax, but in those circumstances, also there would be consideration of a transfer. If Mrs. Chokro had given away the interest in her property during her lifetime, there would have been a gift tax because a transfer.
But she would have had some control over that. She had no control over the Q-tip, did she?
She had no control of the Q-tip, but she could have given her terminable interest if she had transferred it.
She could have transferred something?
She could have. Then there would have been a gift tax.
What could she have transferred having to do with the property in question?
Well, she had
She had a life estate, right?
She had a life estate, right? So she could have transferred her life estate.
Oh, I think, so you say she does have control, and to that extent she could transfer something.
Well, she could have transferred her terminable interest, and then a gift tax would have been generated for federal tax purposes. Massachusetts does not have gift tax or does not have generation skipping tax. Also, a final point, and I think this is an important point, there is no cases that that support the appellant's position. In fact, all of the cases that are still good law today support affirmance of the board's decision. So for instance, in the Maryland case of Controller of the Treasury versus Taylor, like here, there was a federal Q-tip election, but there was no Maryland one. And the Maryland Court of Appeals ruled that under the Maryland statutory scheme, the federal gross estate was the same as the Maryland one. And the court also noted that, in effect, the rules employ a fiction that treats the second spouse as owning the subject property outright, rather than owning merely a life or other terminable interest. And this is the issue of the quid pro quo that the Taylor case and that the Morgan's cases, even I think the Bracken cases, refer to, because you do have this deferral of the tax. You do have this transfer, and almost, even if under property law, Mrs. Chokro had no right to the assets, for tax purposes, the assets are considered as she had owned them. And that's why you have this issue of the second transfer.
I'm not quarreling with you about the cases, except I don't see how you say the Washington State case, Brankin, stands for your proposition as opposed to the estates. I mean, Brankin's saying there was no transfer.
But
I understand the legislature changed it.
Right.
You can't say that the Washington Supreme Court case is supportive of your position.
No, I say all the cases that are still good law today. So Bracken was superseded by a statute, and the subsequent case, Hambleton, from Washington, adopted a very large interpretation of transfer.
Well, we don't have that here, do we?
I'm sorry?
We don't have that large interpretation in Massachusetts, do we?
No, but this court, as I mentioned in the BW case, which I referred in my brief, stated that when you do adopt a federal provision, you do adopt a federal interpretation as well. And because the federal interpretation of transfer is very broad, then this court should also adopt a very broad interpretation of the term transfer.
But you're basically saying that she transferred more than she had, right? Because she transferred not the life interest, she transferred something else to the trustees, right? Trustees now have something that they didn't have before, right?
That's correct.
But it wasn't the same thing that she had.
That is not the same thing that she had, but that is this transmutation of right that happened when she died. And that is this transmutation of right that caused the estate tax to be triggered and to have the inclusion of the, all the assets were included in her estate, on the federal gross estate.
So there's no gift tax in Massachusetts, I gather.
That's correct.
So it turns out, actually, it sounds as if he was worse off to be doing the Q-tip, because if he had simply not had a Q-tip, she would have, the taxes in New York would have been deferred because it all would have been transferred to her. And then she could have gifted all but the life estate to the children.
Right.
And that would not be subject to tax. And then upon her death, all she would have is a life estate, so there would be no tax.
That's correct. But that's the point, is like when you do make a Q-tip elections, you do have to consider the facts that pertain to the second spouse. So if the second spouse does move, you do have to take into consideration where does the second spouse reside. If the second spouse had actually spent all of the assets of the trust, for instance, if these assets had been used to take care of her medical care, there would be no tax because there would be no trust any longer. So you cannot just ignore facts pertaining to the second spouse just because the first spouse made an election. You do have to look at those facts.
I'm confused by the chief's question, though. So the gift tax, would it's completely exempt for taxes, or is there's a limit to what's exempt from tax?
There's no gift tax in Massachusetts at all.
There's no gift tax, so you can just give it away before her death, though, right? She has to give it away before she dies.
Right.
Right, okay.
So there would have been a gift tax under federal law, but there's no gift tax under Massachusetts law.
That's right. There'd be federal tax consequences for that,
That's correct.
but not state tax consequences.
Correct.
So you are worse off ultimately because you're paying the federal income tax beyond $10,000, beyond whatever the $12,000 or $13,000.
Also regarding this issue of transfer, the Connecticut Supreme Court in the Brooks case made a really good point that it would be really illogical to consider that the Q-tip assets are included in the estate of the second spouse, but that you would look at transfer in a very narrow way. And really, this is a basis as to why the concept of transfer should be really broad. So in conclusion, just citing to the Hambleton cases, the great weight of authority support the department's assertion that Congress and the legislature can constitutionally tax Q-tip passing at the death of the second spouse. And for that reason, we would request this court to affirm the appellate tax board's decision.
Okay, thank you.
Thank you.
We'll do a morning break.